All present in the courtroom, please rise. The bailiff's command echoed in Federal Courtroom 24 as Judge Richard Leon entered, his face stern, and known as the Hammer. For his intense questioning and low tolerance for unprepared lawyers, Leon was famous for ending legal careers with a single, sharp remark. Today, and he seemed particularly agitated, the Wilson voting rights case, he stated, his gaze sweeping over the packed room. Let's not waste any time. The state's attorney confidently rose, expecting a swift victory. The government rarely lost these kinds of cases. Then, and a young woman named Jasmine Crockett stood up. No one expected much from her, at just 38, facing a legendary judge in her first major federal case. And, most observers saw it as a lost cause. The odds were stacked overwhelmingly against her and the thousands of minority voters she was representing. And Crockett approached the podium with nothing but a single manila folder. No team of paralegals, no stacks of case files, just that one folder. And the opposing counsel barely suppressed a smirk. Judge Leon's eyes narrowed with impatience. Then, she spoke her first sentence. The room seemed to freeze, and Judge Leon's expression changed instantly. He leaned forward, fully focused on Crockett's words. The government attorney's smirks vanished, and spectators exchanged shocked looks. No one had ever seen the notoriously tough judge react this way. Your Honor, Crockett continued, pulling a document from her folder that no one knew existed. Before I continue, and I'd like to submit a piece of evidence that will completely redefine everything we thought we knew about this case. The document she revealed would not only shock everyone in the courtroom, but it had the potential to reshape voting rights law across America for decades to come. And the case of Wilson versus the State Election Board had started when new voter ID laws effectively disenfranchised 200,000 citizens from voting in the last election. And unlike earlier voting restrictions, these regulations appeared fair on the surface, and requiring specific government-issued photo identification that most Americans take for granted. The real issue was that in the targeted districts, and DMV offices had been closed, had limited hours, or were moved miles away from public transportation. Getting the required ID now meant taking unpaid time off work, and arranging childcare and traveling distances that could reach 40 miles each way. The effect was disastrous. In Westwood County, for example, and voter turnout plummeted by 63% after the new laws. In predominantly minority communities like Eastern Heights, and some polling stations reported turning away hundreds of long-time voters, whose IDs were no longer considered valid, and elderly citizens who had voted for decades suddenly found themselves unable to vote, because their expired driver's licenses were no longer acceptable. And I voted in every election since 1964, 78-year-old veteran James Wilson told reporters outside the courthouse. I fought for this country, and paid taxes my entire life, and now they tell me my VA card isn't good enough to vote, and something is deeply wrong with that. Wilson became the lead plaintiff after walking 3 miles to his polling place, only to be turned away, and Judge Richard Leon wasn't just any federal judge. At 72, he was a figure who commanded both respect and fear in legal circles. Appointed by President George W. and Bush in 2002, Leon had built a reputation for being fiercely independent and unpredictable. He famously ruled against the NSA's phone surveillance program, calling it almost Orwellian, yet had also upheld controversial detention policies. Lawyers preparing for his courtroom studied his past rulings obsessively, knowing he followed no predictable ideology except for rigorous legal reasoning. Law clerks nicknamed him the Hammer because of how he dismantled weak arguments. And if you go into Leon's courtroom unprepared, one seasoned attorney warned, you might as well just give up the case. His incredible memory for case law meant that lawyers couldn't get away with misrepresenting precedents. Several had been publicly rebuked for trying. Facing this intimidating figure was Jasmine Crockett, whose journey to this moment defied all expectations. And raised in South Detroit by a postal worker mother who made enormous sacrifices for her education, Crockett had worked night shifts through college and law school. Unlike the elite lawyers usually seen in federal court, she had spent her career representing people who couldn't afford expensive legal counsel. And before taking on this voting rights case, Crockett had earned a reputation defending the wrongfully accused in criminal courts. Her unconventional approach blended meticulous research with a streetwise intuition for finding evidence that others missed, and she had won a landmark case freeing Marcus Williams, a man wrongfully imprisoned for 12 years, and after finding police misconduct evidence buried in thousands of departmental files. What made this case truly extraordinary wasn't just the high stakes. It was the David versus Goliath matchup. The state had brought in a team of 6 attorneys from one of Washington's most powerful firms, and with over 120 years of combined legal experience, their lead counsel Bradley Thompson, and had argued before the Supreme Court 7 times, and had never lost a voting rights case. His team had filed a 378-page brief attacking Crockett's arguments from every possible angle. Crockett stood alone, with a brief that was just 42 pages long. What observers didn't realize was that Crockett's strategy was a radical departure from traditional civil rights litigation. While most voting rights lawyers relied on broad constitutional principles and emotional pleas, Crockett had spent 6 months building her case differently, and she had visited every affected community, collecting 358 first-hand accounts from voters who had been turned away. She had analyzed DMV locations against census data, and creating detailed maps that showed the unequal impact. Most importantly, she had filed Freedom of Information Act requests that uncovered thousands of internal government emails about the new ID requirements. For 3 weeks, and she had worked 18-hour days in her small office, personally reviewing 1184-2 documents, deep within those files, and she had found something that no one, not even the government's own lawyers, knew existed. The courtroom was completely full that morning, and civil rights leaders sat alongside ordinary voters whose rights hung in the balance. National media filled the press section, and sensing that this case could set a precedent for similar laws in 17 other states, as Judge Leon called the court to order that morning, no one could have imagined they were about to witness one of the most remarkable legal showdowns in recent history, and a confrontation that would not only decide the fate of hundreds of thousands of voters, but potentially reshape how courts evaluated voting rights cases for decades to come. And the courtroom buzzed with anticipation as the bailiff called for order. All rise. The United States District Court for the District of Columbia is now in session. The Honorable Judge Richard Leon presiding. Judge Leon entered, his black robe flowing, and took his seat at the bench, and his piercing gaze scanned the full courtroom before settling on the attorneys' tables. "You may be seated," he said, his voice resonating with authority. "We are here today for oral arguments in Freedom Access Project versus Brennan Election Commission. Miss Crockett, and you may proceed." Jasmine Crockett walked to the podium with deliberate steps, and the clicking of her heels against the marble floor was the only sound in the silent courtroom. She placed a single binder in front of her, though she would rarely look at it. "Thank you, Your Honor," she began, her voice clear and unwavering. "This case is about a simple but fundamental question, and can a state pass voting regulations that appear neutral, but have a demonstrably discriminatory effect? And the Supreme Court has repeatedly held that the right to vote is the foundation of all other rights. When that right is compromised, and our entire democratic system is weakened." She paused, making direct eye contact with Judge Leon, who was already leaning forward slightly, "and the state claims that these new identification requirements are necessary to prevent fraud. Yet, in the 10 years before these regulations were implemented, and there were exactly 7 cases of in-person voter fraud out of more than 14 million votes cast, that's a fraud rate of 0.05%. Who Judge Leon interrupted, and as was his custom, "Ms. Crockett, fraud prevention is a legitimate interest for the state, no matter how rare fraud might be. And the Supreme Court recognized this in Crawford versus Marion County. This was the moment when most lawyers would get flustered or backpedal. Crockett did neither. And you are absolutely correct, Your Honor," she replied, surprising him with her immediate agreement. "And Crawford did establish that fraud prevention is a legitimate state interest. However, and Crawford also established a balancing test that weighs that interest against the burden placed on voters." She then pulled out a map and requested permission to approach the bench. "With the court's permission, I'd like to show you something." Judge Leon nodded, and Crockett unfolded a large, detailed map of the state with various colored overlays. This map shows the impact of the new regulations, and the red areas indicate communities where more than 30% of eligible voters lack the newly required ID. The blue dots represent DMV offices where voters can get this ID. As you can see, in the heaviest red areas, there are practically no blue dots. Judge Leon studied the map with a furrowed brow. "And your point, Counselor?" "My point, Your Honor. And is that for voters in these areas, which are predominantly minority communities, getting the required ID means traveling up to a 175-mile round trip. And for those without cars, that's a 3-hour bus journey each way. if bus service is even available, and the DMV offices in these areas are also only open 2 days per week from 9:00 a.m. to 4:00 p.m., and hours when most working people can't visit without losing a full day's wages. The state's attorney, Michael Reynolds, stood up. "Objection, Your Honor. And the inconvenience of getting an ID does not rise to the level of a constitutional violation." Judge Lyon turned to Reynolds with a stern expression. "This isn't a trial, counselor. Save your objections. You'll have your turn." He then turned back to Crockett. "Please continue." Crockett nodded. "Thank you. And Your Honor, the Supreme Court in Harper versus Virginia Board of Elections established that a state cannot impose a cost on the right to vote. While the state isn't directly charging for the ID, our economic analysis shows that the average cost in lost wages, transportation, and getting required documents like birth certificates amounts to approximately $175 per voter. She continued to methodically build her case, piece by piece, and anticipating and addressing potential counter-arguments before Judge Lyon could even raise them. For almost 40 minutes, she navigated complex legal doctrines and connecting precedents from voting rights cases spanning decades. Judge Lyon, who was usually quick to interrupt with difficult hypotheticals, and found himself listening more than speaking. When he did ask questions, he was met with precise, reasoned responses that showed a depth of preparation rarely seen in his courtroom. Then came the moment that would completely change the direction of the case, and Judge Lyon posed what many considered an impossible hypothetical. "Ms. Crockett, and let's say the state set up a voting system where every citizen was assigned to a polling station based on the last 4 digits of their social security number. If it turned out this seemingly neutral system made minority voters travel twice as far on average without any proof of discriminatory intent, and would that be a constitutional violation?" The courtroom held its breath, and this was the kind of complex legal puzzle that had stumped countless lawyers in Judge Lyon's courtroom over the years. Crockett paused, and carefully considering the question before responding. "Your Honor, that hypothetical is very similar to the Supreme Court's reasoning in Gillian versus Lightfoot, and where a facially neutral city boundary that excluded 99% of black voters but no white voters was struck down despite using geography instead of race as the criterion." She wasn't finished. "However, your hypothetical actually highlights something more important about this case, and the state is essentially arguing that as long as they don't explicitly mention race in their regulations, any unequal impact, no matter how severe, and is constitutionally acceptable." She then made a surprising move that caught everyone off guard. "Your Honor, may I approach again? And there's something specific in the evidence that speaks directly to your hypothetical." Judge Lyon, clearly intrigued, nodded, and Crockett retrieved a document from her table and gave copies to the judge and the opposing counsel. "And this is an email exchange between the Commissioner of Elections and the consultant who designed these new ID requirements. On page 3, and the consultant writes, and I quote, 'The beauty of using these specific criteria is that they disproportionately impact demographic group A, while giving us complete deniability, since they never mention race directly.'" A murmur ran through the courtroom. Judge Lyon's eyebrows rose as he read the document. "And how did you get this email, Miss Crockett?" he asked. "Through standard discovery, Your Honor, and it was among the 50,000 documents provided by the state. I suspect they didn't expect anyone to find it, buried as it was in technical appendices about database management." The state's attorney was frantically flipping through his own copy, and his face turning pale as he found the damning passage. Crockett continued, "This isn't just about unequal impact, Your Honor, and this is about intentional discrimination disguised as neutrality. The Supreme Court in Arlington Heights gave us the framework for identifying exactly this kind of pretextual discrimination." The atmosphere in the courtroom was transformed. What had been the formal tension of a legal proceeding was now an electric feeling that history was being made right before everyone's eyes. Judge Lyon studied the email evidence with intense focus, and occasionally looking up at Crockett with an expression that shifted from skepticism to something rarely seen on his face, growing respect. "Ms. Crockett," he finally said, "you have presented compelling evidence of intent. But even if we agree that these regulations were designed with a discriminatory purpose, and the state argues they have a compelling interest in preventing fraud that would survive strict scrutiny, this was the critical moment, and the last obstacle Crockett needed to overcome." The courtroom fell completely silent, with even the court reporter seeming to hold her breath, and Crockett's response came with quiet confidence. Your Honor, for a law to survive strict scrutiny, and it must be narrowly tailored to achieve a compelling government interest. These regulations fail that test for 3 reasons. She held up one finger. First, and they are not narrowly tailored. Our expert analysis shows that 94% of the burden falls on minority communities while addressing a problem, in-person voter fraud, that statistically doesn't even exist. She held up a second finger. And second, there are many less restrictive alternatives that would achieve the same anti-fraud goal without disenfranchising legitimate voters. And we have detailed 16 such alternatives in our brief. She held up a third finger. And finally, the email evidence shows that fraud prevention was not the real reason behind these regulations. The court has consistently held that false justifications cannot satisfy strict scrutiny. She then revealed what would become the most talked about moment of the entire proceeding. And Your Honor, with the court's permission, I'd like to introduce one final piece of evidence that we only got yesterday. Judge Leon nodded, and Crockett handed a sealed envelope to the clerk, who gave it to the judge. As he opened it, his expression changed dramatically, and inside was a confidential memorandum from the Election Commission's own security team, dated just 2 weeks before the new regulations were announced. It explicitly stated, after a comprehensive review, we find no evidence that in-person voter impersonation presents a significant security risk to election integrity, and resources would be better used to address actual vulnerabilities in the election system, particularly in the area of cybersecurity. Judge Leon looked up, his eyes wide. This directly contradicts the state's central claim about the purpose of these regulations. Yes, Your Honor, Crockett replied. The Commission ignored its own security team's findings because the true purpose of these regulations was never about preventing fraud. The state's attorney, Michael Reynolds, jumped to his feet. Your Honor, we have never seen this document. We object to its late introduction. Judge Leon fixed Reynolds with a stern glare. And Mr. Reynolds, this appears to be your client's own internal memo. Are you claiming the Commission withheld it during discovery? Reynolds hesitated. I would need to speak with my client, Your Honor. I suggest you do that immediately. Judge Leon replied, his voice a low and dangerous tone. This court takes discovery obligations very seriously. He turned back to Crockett, studying her with new intensity, and the entire gallery could feel something unusual happening. Judge Leon, known for his unreadable face during arguments, was visibly impressed. Amens. Crockett, Judge Leon said, his voice carrying through the hushed courtroom. In my 30 years on this bench, I have never seen legal reasoning of this quality. And you've just completely reshaped how we should evaluate this case. The statement sent shockwaves through the courtroom, and legal observers would later say they had never heard Judge Leon offer such direct praise during proceedings. But what happened next truly electrified the room, and instead of simply acknowledging the compliment, Crockett responded, "Thank you, Your Honor. But this case isn't about legal reasoning or attorney performance, and it's about the fundamental right of every American citizen to cast their vote without facing artificial barriers designed to silence their voice. And the 150,000 voters who have been effectively disenfranchised by these regulations deserve this court's protection far more than I deserve any praise." The response shifted attention from her personal achievement back to the constitutional principles at stake. Several people in the gallery nodded in silent approval. Judge Leon leaned back slightly, a rare smile briefly crossing his face. "Well said, Counselor. Well said indeed." He then turned to the state's attorney. "Mr. Reynolds, I suspect you have your work cut out for you. You may begin your argument." Reynolds approached the podium looking visibly shaken. His confidence had disappeared as he shuffled through his notes, and, trying to regain his composure, "Your Honor, while Ms. Crockett's presentation was certainly impressive, and she fundamentally misrepresents the state's position and the applicable law, his argument never gained any momentum." Judge Leon interrupted repeatedly with pointed questions that showed he was now viewing the case through the framework Crockett had established. "Mr. Reynolds, and how do you reconcile your fraud prevention argument with your own security team's memorandum stating that in-person fraud is not a significant risk? And how do you explain the email that explicitly talks about using neutral criteria to target specific demographic groups, and given that only 0% and 5% of votes involved alleged fraud? And how is this sweeping regulation that affects 17% of eligible voters narrowly tailored? Reynolds struggled to provide convincing answers, and by the time he finished his argument, the outcome seemed more and more certain to everyone in the courtroom. When Crockett rose for her brief rebuttal, and she spoke with a quiet conviction that filled the chamber, "Your Honor, this case isn't about complicated legal doctrines, and it's about whether our Constitution allows the government to create a system where some citizens must overcome significantly greater barriers than others to exercise their most fundamental right in a democracy. And the evidence and precedent before this court provide a clear answer: it does not." As she gathered her materials and returned to her seat, the courtroom remained silent. Everyone felt they had just witnessed something extraordinary. Not just brilliant legal advocacy, but a turning point in the ongoing fight to protect voting rights. The impact of that historic courtroom confrontation was felt far beyond the walls of the courthouse. As Jasmine Crockett walked down the courthouse steps after the hearing, and she was met by a sea of reporters and cameras, all eager for her reaction. "Ms. Crockett, CNN here. What was your reaction to Judge Leon's unprecedented compliment?" She paused thoughtfully before responding. "What matters isn't any compliment to me, but whether the court upholds the constitutional rights of the voters who have been silenced by these regulations. This case has always been about them, and not about any individual attorney." Her response was widely praised for directing attention to the real issues at stake, instead of making the victory about her personally. Behind the scenes, the state's legal team was in crisis, and multiple sources reported that emergency meetings were held to discuss a potential settlement before Judge Leon could issue what many now expected to be a scathing ruling against them. Legal experts across the political spectrum recognized the significance of what had happened. Harvard law professor Lawrence Tribe tweeted, "What Jasmine Crockett did today wasn't just brilliant advocacy. It was a masterclass in constitutional litigation that will be studied in law schools for years to come." Even conservative legal scholars acknowledged the power of her presentation, and former Solicitor General Paul Clement noted on a legal podcast, "Regardless of where you stand on the issues, the quality of advocacy by Ms. and Crockett was exceptional by any measure, and she systematically dismantled the state's position with precision and a remarkable command of both precedent and factual evidence." 3 weeks later, and Judge Leon issued his ruling. In a comprehensive 87-page opinion, he granted a preliminary injunction blocking the implementation of the voting regulations. And the opinion began with an unusually direct tone. "This case presents a textbook example of regulations that, while appearing neutral, and were designed with the specific intent to limit the voting rights of minority citizens. The evidence of discriminatory intent is overwhelming, and the state's justifications cannot survive constitutional scrutiny." Judge Leon's opinion established a new framework for evaluating voting regulations that had an unequal impact on minority communities. And he wrote, "When a voting regulation imposes substantial burdens that fall disproportionately on minority communities, and courts must look beyond simple claims of legitimate purpose, evidence that officials were aware of and intended such unequal impacts, whether from internal communications, statistical analysis, or contradictions between stated reasons and internal assessments, can establish unconstitutional discriminatory intent even without explicitly racial language." The ruling sent shockwaves through state legislatures across the country, and within days, officials in 5 other states with similar pending regulations announced they were reconsidering their approaches, and voting rights advocates in a dozen states filed new legal challenges to existing regulations, citing Judge Leon's opinion as a powerful precedent. And for the thousands of affected voters, the impact was immediate and real, and the state was ordered to suspend the ID requirements and create a new plan that would ensure equal access to the polls for all eligible voters. In the next election, and turnout in previously affected communities increased by 31%, 2 months after the ruling, and Jasmine Crockett was invited to give the keynote address at the American Bar Association's annual Civil Rights Conference. Her speech, entitled "Constitutional Advocacy in the Modern Era," would later become required viewing in law schools nationwide. "The Constitution's promises aren't automatic," she told the full auditorium, "and they require advocates who are willing to do the painstaking work of connecting abstract principles to real-life experiences." When we let legal technicalities overshadow fundamental rights, we betray the document we claim to respect, she concluded with words that would be quoted by future generations of civil rights attorneys. The most powerful tool in constitutional advocacy isn't eloquence or ideology. It's preparation, the unglamorous work of mastering the facts and understanding the precedents and anticipating every counter-argument before you ever step into a courtroom. And that preparation happens in quiet rooms with stacks of documents, not in front of cameras. But when the time comes to stand up for someone's rights, and that preparation becomes power, perhaps the most meaningful recognition came from Judge Leon himself. In a rare post-decision interview with Legal Times, and he was asked about cases that had changed his thinking on constitutional interpretation. "You know," he said thoughtfully, "and judges are supposed to be influenced only by the law and the facts. But sometimes an advocate presents those elements with such clarity and precision that it illuminates constitutional principles in ways you hadn't fully considered before." And the voting rights case argued by Ms. Crockett was one of those moments. The most lasting impact wasn't felt in Washington, but in communities across America. And in the years that followed Judge Leon's decision, states were forced to reconsider voting procedures that had created obstacles for minority, elderly, and disabled voters. Access to the ballot box expanded, and voter participation increased. The democratic process became more inclusive, and law professors now teach the case alongside landmark voting rights decisions. And constitutional law textbooks include excerpts from the oral argument and Judge Leon's opinion. A new generation of lawyers studies Crockett's techniques and approach. For Jasmine Crockett herself, the case became both a defining achievement and a launching pad for wider influence, and she continued her civil rights work with a new level of national recognition, focusing on voting rights, criminal justice reform, and economic equality. And she remained grounded in the communities she served. When asked by a reporter if she saw herself as a legal superstar, after the case, she smiled and shook her head. "I see myself as someone doing the work that needs to be done. There are millions of Americans whose rights are vulnerable, and my job is simply to use whatever skills I have to help protect those rights." The lesson of that remarkable courtroom showdown wasn't just about legal strategy or persuasive skill. It was about the power of meticulous preparation, moral clarity, and an unwavering focus on fundamental principles. And it was about the difference one person can make when they combine deep knowledge with passionate advocacy. For those who witnessed that historic day, and the memory remains vivid: a quiet courtroom, a brilliant advocate, an impressed judge, and constitutional principles powerfully upheld. For the thousands of voters whose rights were protected by the resulting decision, the impact continues in something more fundamental, and the ability to participate as equal citizens in American democracy.